Hey everyone, welcome back to my channel. My name is Incase, aka the Light Lawyer. Today we are going to look at the introduction to law, and the topic is the sources of law. And this is basically important, especially for the year ones to understand, because this topic lays a foundation and a benchmark of law in regards to other questions that you will be encountering. You must know the sources of law, and today that's what we are going to discuss and interact in our discussion today. And if I can give a brief overview about the sources of law, some people can say that we have written laws, we have common law, doctrine of equity, customary law, but we are going to go deep into them and we understand what each of them means. So I'm going to start with the definition of law. What is law? So law, it refers to the set of rules governing in a society, or another person can say that law, it refers to the rules of conduct imposed and enforced by the sovereign. So in this second definition, this is whereby the sovereign, it can be the government, it can impose laws, and now those laws are supposed to be followed and abide by the people, the inferior people. So it's like the government can pass out laws, and these laws are to be followed by the people. And failure to abide these laws, there are sometimes consequences, or what we call punishments. So now another question would be, where do these laws emanate from? The origin of these laws, where do they come from? So we have, according to Article 79 of the Constitution, the 1995 Constitution, it provides that the Parliament has the power and the mandate of making laws. And now we also have two categories of sources of law. And those two categories that we're having, the first one we're having primary source, and another one we're having secondary source. So I'm going to first deal with the primary source of law. The primary source of law, the first one we have the Constitution. The Constitution, as in Uganda, we're having what we call the 1995 Constitution of the Republic of Uganda. This is the grand norm, and this is the landmark. And all laws must be consistent with the Constitution. Back when the Constitution has the grand norm, we're having Article 2 of the 1995 Constitution. Article 2 of the 1995 Constitution provides that any law that is inconsistent with the Constitution is null and void, meaning that all other laws must be in conformity with the Constitution. If at all other laws that are inconsistent, that are not in line, that are not in conformity with the Constitution, they are null and void, and therefore they are not applicable. And the landmark case we're having a case of Paul Kagwa, Semogerere and another, versus the Attorney General. It's number 3 of 2000. In this case, the Constitutional Court held that the Constitution is the supreme law of the land and has binding authority on all persons, and any other law inconsistent with the Constitution is null and void. So basically, this case is supplementing on what Article 2 of the Constitution says. So, as we proceed, we have what we call the written laws or the Acts of Parliament. The Acts of Parliament can be the statutes, the legislations, and these Acts of Parliament, these are the statutes that are made by the Parliament. For example, we have the Penal Code Act, the Contracts Act, the Evidence Act, and so many other statutes that we're having in Uganda. And according to Article 79, just as I earlier mentioned, Article 79 of the 1995 Constitution, it gives the Parliament the mandate and the power to make these laws. So these statutes are established, or they are formed by the Parliament, since the Parliament has the power to make these laws. And also we're having Article 91, it provides the procedure on how a bill turns into law. And if you read this Article 91 in detail, you will see that the parliament, the members of the parliament, it can be a minister or a member of parliament, they can pass a motion and pass a bill, and this bill is debated, and after being debated and after all the stages have been implemented into, they take the bill to the president to assent, and once the president assents this bill, it becomes a law, and therefore it's binding. But however, if at all the president refuses to assent the bill and this bill goes back to the House, let me say for 2 times, then automatically this bill will pass into law. So therefore, this clearly shows that the parliament, it has the power to make laws. Even if, let me say, they pass a bill and they take it to the president for assent and the president fails to assent, but for the second time, it has power to pass it as law. And this can be possible through a majority vote of 2/3 of the members of parliament. So by a vote of 2/3, the bill is passed as law. Then according to Article 92 of the 1995 Constitution, it provides that the parliament cannot pass law that removes or prohibits or resolves the dissolution that was made by a court. In simple terms, it prohibits retrospective legislation. Retrospective legislation simply means that they do not have the power to impose law that acts retrospectively, that acts backwards. If at all, let me say, the court has held a decision, the parliament cannot form a law that acts retrospective to defer or to alter the decision that was made by the court. So it does not have that power. So all the laws that they make, they are not retrospective. So according to the case of Maria Matemba and others versus the Attorney General, it's volume 3, High Court Bullet 2003 on page 84. Here, in this case, the petitioners, they challenged the amendment bill, and that amendment bill was known as the Omnibus Bill in the Constitutional Court. For them, they were claiming that this bill, it was inconsistent with the Constitution. And the Constitutional Court held that the legislature is the one that has power to make the laws, and therefore it cannot intervene. The essence of this decision was that these petitioners, they brought the case when this bill was still in parliament. It had not yet been a law. And therefore here, in the decision and the judgment of the court, they held that they cannot intervene because the parliament has the power to make laws. And therefore, since that bill was still under parliament, it was not yet passed as law. Therefore, it shows that the courts of law cannot intervene since the parliament, it's the one with the sole mandate of making laws as illustrated under Article 79 of the 1995 Constitution. Then another source of law we have in the common law, or you can say the case law. Case law is a very important aspect because the law is guided by case law, by the precedents on what was already been decided. So case law, this refers to the body of laws that guides courts in decision making. Let me give an example. If at all the High Court wants to make a decision on a case at hand, it will look at the precedents or the previous cases of the same circumstances to come up with a decision. Meaning that the judges, the judicial officers, they are bound to follow the case law. They cannot alter or differ from what was already decided. And the precedents, they follow in order, whereby the Court of Appeal has to follow what was decided by the Supreme Court, and also the High Court has to follow what was decided in the Court of Appeal. And also, the Chief Magistrate Court has to follow what was followed in the High Court Court of Appeal, the Supreme Court. So basically, it's about precedent. You have to follow what was already decided. You shouldn't come up with something new. So, however, there are some circumstances whereby the courts are obliged not to follow the case law. For example, if at all, in case where the circumstances differ with the previous cases, we are in a changing society. So things differ. So if at all the case at hand differs from the previous cases, then the judicial officer is not obliged to follow the previous cases. He has to come up with a judgment, but obviously he has to be fair and he has to make sure that justice must prevail. And another circumstances whereby the judicial officer might not follow the case law is, for example, where the cases are rigid or ambiguous. There are some cases, the judgments, whereby they are ambiguous and they are rigid, and in such, the court or the judicial officer has to differ from such judgments and make new judgments. So, another source of law that we have in under primary is the customary law. Customary law is provided under Section 14, subsection 2 of the Judicature Act. It lists down the laws applicable in Uganda, and among those laws, we have in the customary law. The customs can be exercised in courts of law, and here, where a common law conflicts with the customary law, a customary law shall prevail. So, here we are looking at if at all the common law and the custom, they are in conflict, the customary law shall prevail according to Section 14, subsection 2 of the Judicature Act. The case law we're having Kabaka's government versus Musa Chitoto. It's a case of 1965, East Africa, on page 278. Here, the court held that the customary law prevails over the common law. So basically, in this essence is that if at all there is a conflict between common law and customs or customary law will prevail. Then also having Section 10, subsection 1 of the Magistrate Courts Act. It provides that the courts shall administer customary law in exercising its duties while deciding cases or making judgments. Meaning that here judicial officers must include customary laws while making judgments. Also, we're having sources of customary law. Where can we find these customary laws? Customary laws are not written anywhere, but the question is, how can we find these customary laws? Where are they? Customary laws, these are like a set of norms that are in different localities. Let me give an example. When you go to Bagisu region, you find that they have a custom of male circumcision. Whereas when you go to Baganda, you find other different customs. For example, you cannot marry a person that you guys are related of the same clan, as in related in the case of Juliet Namazi and another versus. So it's a landmark case also there in regards to customary law. Then when you go to other regions, you also find totally different customs. So these customs are different depending on the locality or depending on the society. Now the question comes, where do you find these sources of customary law? The first aspect where you can find these sources of customary law is in judicial notice. Judicial notice, it refers to an instrument used by court to acknowledge a given custom. So a judicial notice is basically like an instrument from court that specifies that such and such a custom is recognized, and therefore there is no need to go to look for witnesses, there is no need to go to look for other experts to acknowledge that such and such a custom it's existing. Judicial notice it's evident enough to prove or to clarify to court that such a custom is acknowledged, and therefore it has to be acceptable in courts of law. According to Section 55 of the Evidence Act, provides that the court provides that if a court adduces judicial notice, there is no need to bring other evidence, meaning that judicial notice is a conclusive evidence on the acknowledgement or on the applicability of a custom in a specific locality. Another source of customary law is expert evidence. Expert evidence is provided for under Section 53 of the Evidence Act and provides that experienced people, those are experts, they come and they give evidence, they give knowledge on the existence of a particular custom in a specific locality. So these are the people who come and testify that a specific custom exists. And one of the characteristics of a custom, number one, it must have been in place for over so many years, to the extent that no reasonable person can tell its existence, meaning that it should have been in place for so long. Another characteristic of a custom, it should be applicable. Number three, another characteristic is that this custom must be consistent, and they must be their actions. They shouldn't be inconsistent with the Constitution, and also they must be consistent with the natural conscience and justice. Meaning any custom that is inconsistent with the 1995 Constitution, since the Constitution is our grand norm, that custom will be null and void. So for a custom to be recognized as a custom, it must be in conformity with the Constitution. Then another source of this customary law is textbooks. Some textbooks they have those customs. Some prominent scholars wrote about these customs in various localities. For example, when you look at most books, you will see that in Bagishu region there is male circumcision, and that's a custom. In Buganda, you see a custom of bride price. So all these, they are found in textbooks. So if we can move, another thing, we have the doctrine of equity. The doctrine of equity, these are basically about fairness. They talk about fairness, and this doctrine of equity, they are implemented through maxims. And these maxims, for example, we have equity does not aid the vigilant. Where two equities are equal, the first in time prevails. Equity follows the law. So basically these maxims, they are indicators of fairness. So doctrine of equity is one of the source of law that the court has to follow, and also is provided for under the Judicature Act, Section 14. So if you can proceed to the secondary sources. On the secondary sources of law, we have delegated or subsidiary or statutory instruments. These are the laws made by the executive, for example, like the ministers. The ministers, they are given power to make laws. And now these laws govern the specific offices they had. For example, if at all, let me say, the Minister of Health makes laws, these laws will only govern the Ministry of Health. It will only govern the Ministry of Health. And according to Section 79, Article 79, of the 1995 Constitution, the mandate is given to the Parliament to make laws. But however, under Clause 2, the Parliament has the power to delegate to other organs to make laws. That's now how we are saying the executive having the power to make laws. And also under Section 14 of the Interpretation Act, it defines a statutory instrument as a document to which power to make laws is delegated. And also, according to Section 16 of the Interpretation Act, provides that every statutory instrument published must be published in the Uganda Gazette. So, if I can also take you back, according to Article 91, when a bill is to be made as a law, if at all the president passes that bill as a law, it has to be published in Uganda Gazette. So it is a prerequisite for those laws to be published in Uganda Gazette so that the public is aware of the existing laws. Then also other secondary sources we have in ordinances. Ordinances, they are provided for under Section 38, subsection 1 of the Local Governments Act, where the district council has power to make laws that are not inconsistent with the Constitution. And remember, according to Article 2 of the 1995 Constitution, that says that all laws must be consistent with the Constitution. If at all a law is not consistent with the Constitution, it's null and void. Then also, we have another source of the secondary law, it's bylaws. Bylaws are also defined under Section 39 of the Local Governments Act, which provides that the lower government councils, for example, the sub-county, the village councils, they have power to make laws. So meaning these village LC councils, they can make these laws. But remember, these laws should not be inconsistent with the 1995 Constitution. Another secondary source we have in directions. Directions, according to Article 138, Clause 1, Paragraph B, it provides that the Chief Justice has power to make orders or directions to courts for proper administration of courts and justice. Basically, this provision, it empowers the Chief Justice to make laws in form of directions to guide the courts of law on how to administer justice and on how to handle cases. So this provision, it empowers the Chief Justice to make laws, and these laws are called directions. So another source of law, we have rules. Rules, they are provided for under Section 40 of the Judicature Act. You can go and read further about that. Then we also have regulations. We also have scholars, textbooks. We have prominent scholars who wrote various textbooks, various topics. For example, we have Professor Kanyehamba. His books can be used as reference. So these are some of the secondary sources of law that we have in Uganda. And also, we have international law. The reason that's why I didn't first bring international law is that most people, they know primary and secondary. So I've just added international law to widen your research. International law is provided for under Article 123, Clause 1 of the 1995 Constitution, which provides that the Parliament or the President can conclude treaties. There is ratification of treaties. So basically, under Article 123, it simply shows that the government of Uganda can engage and conclude in various international treaties. And this is governed by the Ratification of Treaties Act. So meaning that since we can ratify to these international laws, meaning that these international laws bind on us, with the Ugandans, and therefore we have to adhere to these international laws. So basically, in simple terms, these international laws are also sources of law in Uganda. Well, that's it for today about the sources of law. So if at all you find this discussion hopeful, you can simply subscribe and like and follow, so that if at all I post other important topics, you are not left out. So I'm here to simplify the law, to guide, and if at all you have any question, just ask in the comment section. I will respond. And if at all you want a one-on-one session, my numbers are there in the biography. Then you can tap on me and we engage, and we can make dreams happen. Thank you very much. I sign out.